Alright, once again, good morning, students at the West Pacific University. This is your continuation of the lecture of the law of contracts. In our initial lecture, we looked at the origins of the law of contracts. We looked at the place of the law of contracts and how societies, when they commune together, commerce and trade increased. As a result, there was a need of a set of rules to sort of govern the relationship, the transactions, and the commercial relationship. And then also we looked at one of the essential elements of a legally binding contract, which is an offer. Now we're going to look at acceptance, we're going to look at consideration, and we're going to look at intention to create legal relations. Please do understand that these are essential elements of a contract, and these elements must be present for there to be a legally valid and binding contract. So if you look at the slide on page 4, two or more parties form an objective agreement, offer and acceptance must be sufficient, complete and certain. There must be intention, and there must be consideration. Well, we already looked at offer. Now let's look at acceptance. When you look at offer and acceptance, these are sort of these are essential elements of a contract which must be present for a contract to be formed. So if you look at an agreement requires a meeting of the minds or courtesies ad idem. On a conventional offer and acceptance analysis, there is an agreement if there is an offer which is accepted. So there is an offer which is accepted, there is agreements. Courts sometimes use the global approach, looking at the totality of the evidence and making a judgment call on the existence of an agreement between the parties. So the courts will look at whether there is an offer and whether there must be a valid acceptance. So acceptance of an offer must show the fact of the acceptance and the communication of the acceptance. Going back to me selling my 5 for 100,000 kina, the offer is made, and if someone accepts it, they will say that yes, I accept the offer to pay for 100,000 kina for the 5, and I want to buy your car. So they've communicated the acceptance to me. That's basically what we mean by acceptance. So an acceptance is an unqualified assent to the term of the offer. When someone is accepting an offer, they are assenting to the terms. So as soon as you accept something, you bring the contract into existence. So it creates what we call the meeting of the minds, or in Latin it's called consensus ad idem. That means that the minds have agreed on a certain equilibrium or meeting point. In this case, my Toyota 5 and the person accepting the offer, the buyer, is 100,000 kina. So always to determine whether there is offer and acceptance, like I said yesterday, it's an objective test, or in law we call it the reasonable man's test. The reasonable man's test basically is a reasonable man outside the contractual relationship looking in, and the conclusions he or she will form. Alright. In terms of the offer, when it's made and acceptance is given, the acceptance must be on the faith of the offer. So the acceptance is derived or is a response to the offer. This can be made pursuant to this knowledge and performance on recourse acts, and this cannot accept in ignorance of the offer. So you cannot really do away with the offer. You have to accept the offer. That's what basically slide 7 with the wanted sort of poster there is depicting. Alright, the acceptance must be communicated to the offerer. So in order to be effective, the acceptance must be communicated to the offerer. So the person making the acceptance must communicate to the offerer that the acceptance is made. The right to communication may be waived by the offerer, but in some cases, acceptance always must be communicated. Alright, let's look at acceptance by telephone. So if I sell my car and Joe calls me and says, I want to buy your car, I'll give you this amount of money, can you sell me the car? So in the case in PNG, in terms of acceptance by telephone, we use the case of Arinako versus Miles Minape. Apologies for the typing error in your slides there. Basically, in that case, it was held that the contract made by telephone is complete only when one party hears the answer of the other party accepting the offer. So in my case, as soon as Joe gets on the phone and says that, "Are you selling your car for 100,000?" I said, "Yes." He says, "I accept your offer." When he says that, and when I hear it, the acceptance by telephone rule is that acceptance has been made. So as soon as you hear someone say, "I accept the offer," that's acceptance by telephone. Alright, then acceptance by postal rule. So the postal acceptance rule. Remember, these rules were crafted when we did not have mobile phones at the time. So one of the major forms of accepting offer was through post. This sort of provoked the court to declare rules as to how to accept an offer by post. The expression of the postal acceptance rules was formulated in the case Adams v. Linsden, and basically it says that the circumstances are such that it must have been within the competence of the parties that according to the origins of mankind, the post may be used as a means of communicating the acceptance of offer. The acceptance is complete as soon as it is posted. So in the olden days, if you're trying to accept something, as soon as you write "I accept" and you post it, that is considered valid acceptance. It does not matter if the post has reached the seller, but the postal acceptance rule was that if you post your acceptance, it is valid acceptance. If you look at the postal acceptance rules, there's always been a lot of problems with the postal acceptance rules because of the fact that it says that if you post something, it is valid acceptance. So if you look at slide 11, there's a case there that I've put up, Talaman and Co. versus Nathan Merchandise. Basically in this case, Dixon CJ, Dixon Chief Justice, and Falga J, Justice Falga, posting not acceptance unless it is inferred that offerer contemplated and intended that this offer might be accepted by doing of the act of posting. It is so difficult to settle. So sometimes, what basically it's saying is that the person selling the goods must agree that acceptance is done by post and acceptance is done when the letter is posted. Then you look at another case there, World vs. Agricultural Finance Pty Limited. This is until there is a case whose outcome depends on the percentage of the postal acceptance rule, it is safer to approach on the basis that law as stated in English cases continues to be the law in Australia and in Papua New Guinea as well, until and unless it changes when someone posts an acceptance that is valid acceptance. Alright, there's some limitations to the postal acceptance rule. Basically, the letter correctly addressed and stamped. So your acceptance, you have to correctly put the right address and correctly put the stamp, and you have to send the letter during postal service operating normally at that time. So you can't be sending a letter at 1:12 in the night saying that it's valid acceptance, because basically there is not an operating time. And then you look at some limitations of the acceptance rule, some mischievous consequences, and also the parole, not the paroles, but the postal acceptance rule applies to telegrams. So telegram is an old word of communication. I've never used one, so I'm not clear about what a telegram is. But these are some of the cases that highlight acceptance by telegram. The most important thing that I want you to know is that nowadays, with the use of email, under the Unique 12 Model Law of Electronic Commerce, 1996, supplemented by the United Nations Convention on the Use of Electronic Communication in International Contracts 2005, the act in force in the world is that the time of dispatch, time of receipt, place of dispatch, and place of receipt is an electronic environment. So basically, an email, as soon as the email is sent and you receive the email signature that it is sent, there is sufficient acceptance. Alright, the person offerer, the person making the offer, can prescribe the method of acceptance expressly or impliedly. So What happens if it's sent by a different method? You read that case of Manchester Diocese Council for Education for CNG investments. If no method can accept by any method objectively intended. So if the offerer doesn't state any method, you can either call in, you can email, you can basically communicate your acceptance. Alright, another important aspect. Can silence be acceptance? So if I offer you something and you be silent, does that mean that you have accepted the offer? Basically, the rule is that mere silence and inactivity does not generally constitute acceptance. Mere mental action is not enough. Sometimes must be done from which an intention to accept may be reasonably being fair. So if someone is silent, that does not mean that they have accepted your offer. The case is Feldhaus versus Bindley. Acceptance can be inferred from conduct, also known as implied acceptance. So sometimes you sell a car and someone comes in and gives you the money, starts the car and take off. Basically, their conduct has sort of accepted your offer. So that's what I mean by acceptance inferred from conduct. Alright, I've highlighted some case for you to just basically note there. Then if you look at slide 22, it is important that under the mirror image rule, the acceptance must be unqualified and correspond with the offer. So if I'm selling a car, you cannot accept me selling a boat, because I'm not selling a boat. Your acceptance does not correspond or with the offer I'm making. So it's called a mirror image rule, that offer is made and acceptance must match the offer. Alright, I'll give some cases there. And now I'll talk about the effects of acceptance. So when you accept something, it settles facts of the agreement. So the agreement is settled when something has been accepted. When you accept something, it settles time of the agreement. That means that the time exactly when you accepted the offer. And then it settles content of the agreement. So if you sign a contract for sale of a car, you've accepted all the express and implied terms of the contract. And also acceptance, the place of the agreement, where the acceptance is communicated to the offerer. And basically the last slide there on page 24 is the offer and acceptance are not requirements. Court don't need to find agreement, but offer and acceptance are convention analysis. So offer and acceptance are mandatory in forming valid binding contract. I've highlighted some prescribed readings there just for you to further your knowledge. However, the lecture note should be sufficient with understanding the basic content of offer and acceptance. Alright, now we're going to look at an important aspect of contract law. It's an essential element like offer and acceptance. It's the word consideration. Consideration. So if you see the first slide, identify what promise you're questioning the enforceability of. And secondly, ask whether the other party gave in return for that promise. So basically, when you're trying to determine consideration, you think about what promise are you trying to enforce, and then what did you lose, and what did the other party give in return. Think about those important concepts when we look at the issue of consideration. Identifying the issue. So you look at the diagram there. There's a diagram of Jack and Jill. So Jill offers to sell TV to Jack for $250, 250 kina. Jack agrees to buy that price. Jack pays Jill $250. Jill later refuses to supply the TV. Which promise are we going to enforce? What consideration was given in return for the promise? So you look at the example there. TV, 250 kina of $250. So Jack pays. The money is already with Jill, and Jill does not supply the TV. So which promise are we trying to enforce? If you follow along, you will know that we are trying to enforce the promise that Jill is going to give the TV to Jack. So Jill becomes the promisor, Jack becomes the promisee. What consideration was given in return for the promise? Jack has given the money. The money is Jack's consideration. Jill's consideration should be the TV. This is the price of the promise, as I mentioned earlier. Alright, now for the next lecture we will go on to look at consideration in detail.